Good morning, everyone, and we are on our last part of the lesson series on arrest. And today we will tackle what we left as part of our rules of court as a source of the rules on arrest. And also, we will tackle one case decided by the Supreme Court as jurisprudence is one of the sources of the rules on arrest. Now, how arrest or when is arrest done? It is done at any time or any day and at any time of the day or night, according to Rule 113, Section 6. Now, it can be done with a warrant by an officer. That officer must inform the person to be arrested of the cause of the arrest and the fact that a warrant of arrest has been issued. If you look at the screen, I purposely put an asterisk that a fact that a warrant of arrest has been issued in this line, because it does not necessarily mean that the warrant of arrest must be shown to him during the time the arrest is effected. It could be done after the arrest. Now, it can be done also without a warrant by an officer, but that officer is under the law obligated to inform the person to be arrested of his authority to arrest and the cause of the arrest. So another two things that must be done, or the arrested person must be informed of. And what if a private person is called out to help another officer to do the arrest? That private person must arrest that person and inform him the intention to arrest that accused and the cause of the arrest. So take note of another two things. Now, rights of the arresting officer. We have to take note that aside from the accused having the constitutional right, the arresting officer has the right to summon orally as many persons as he deems necessary to assist him in effecting the arrest. So he can call out other people, especially the public, to help him quell the force or the person to be arrested. Now, he can break into any building or enclosure where the person to be arrested is or reasonably believed to be. So if he thinks that that person is inside, so he can break into. And if and when he is inside already, he can break out therefrom when necessary to liberate himself. We are referring again to the arresting officer. Now we go to our jurisprudence. I picked this landmark case, and I remember my criminal procedure teacher assigned this as a reading assignment, the People of the Philippines versus Mumstead case. It is docketed as GR number 91107, and it was decided by the Supreme Court on June 19, 1991, and the Supreme Court decided en banc, meaning the complete number of judges were helping in deciding this, and the one who penned the decision is Justice Padilla. Now, this Mumstead is a Swedish national, and he entered the Philippines as a tourist. He went to Sagada and was arrested in a checkpoint in Tublay Mountain Province. And although I know that we, for those who are looking at the slides now, but I'm making the discussion as you can see also, because there are those who might have troubles with their vision. So I'm doing the oral discussion now. Okay. To continue, a checkpoint was set up after persistent reports that vehicles from Sagada were transporting illegal drugs. And what happened? Mumstead was the only foreigner riding in a bus which passed through the checkpoint. I'm sorry if you can hear that. That's an airplane passing by our house. Okay. I'm sorry for the interruption. Now, the officer who is a member or who did the checkpoint, the officer noticed a bulge on Mumstead's waist, and he suspected that it was a gun on the waist of Mumstead. Now, the officer asked for the passport and identification papers of Mumstead. However, he refused. He did not comply, and the officer asked to bring out whatever it was that was bulging on his waist. Then the bulging object turned out to be a pouch bag, and when he opened it, it was Mumstead who opened it. It was noticed that there were 4 suspicious looking objects wrapped in brown packaging tape, and when opened by the officer, you have to take note, it was Mumstead who opened the bag, and it was the officer who opened the suspicious looking objects wrapped in brown packaging tape. And it turned out to be hashish, which is a derivative of marijuana. Now, when asked to get out of the bus, Mumstead, according to the case, he stopped to get 2 traveling bags in his luggage carrier. And when opened by the officers in the checkpoint, a teddy bear was found in each bag. And feeling the teddy bears, the officers noticed that there were bulges inside which did not feel like foam. Like in the usual teddy bears, there's foams to stuff it. It was only this time that Mumstead presented his passport. Now, the issue here whether Mumstead is guilty actually, but when he was criminally prosecuted for violation of the Dangerous Drugs Act back then in 1991, which is back in RA 6425, he pleaded not guilty during his arraignment, and his defenses were illegal search of his personal effects without warrant, and the hashish was planted by the NARCOM officers, and the 2 traveling bags were not his but was entrusted to him by an Australian couple. Now, what the Supreme Court, or the RTC first, the RTC found him guilty, and the arrest, the Supreme Court said that the arrest is considered to be in flagrante delicto, meaning he was caught in the act, and there was sufficient probable cause that Mumstead committed the offense. Now, what is probable cause? The Supreme Court said that probable cause are facts and circumstances which could have led a reasonable, discreet, and prudent man to believe that there was an offense, I have to quote this from the Supreme Court, has been committed, and that the objects sought in connection with the offense are in the place sought to be searched. This is probable cause when it comes to search. Now, accordingly, the Supreme Court gave examples of valid warrantless search of personal effects. Number 1, smell of a marijuana emanated from a plastic bag owned by the accused. Second, the accused was acting suspiciously, and an attempt to flee on the part of the accused. Now, these are the facts. Legally, we just found out the legal basis of why the Supreme Court affirmed the conviction of Mumstead. The facts that would justify the arrest of Mumstead. The persistent reports received by NARCOM officers. NARCOM received an information a few hours before the arrest of Mumstead that a Caucasian is traveling from Sagada to Baguio City, was carrying with him prohibited drugs, and no time to obtain a search warrant during that time. Now, it happened during a routine check of the bus where the accused was. So that could justify that there's a checkpoint there, and this is the most crucial, that he failed to present his identification papers when he was ordered to do so. We hope in this very short lesson we were able to grasp the rules on arrest, and especially when it comes to probable cause and the surrounding circumstances as considered by the Supreme Court that could justify an arrest even without a warrant. Now, we, again, the members of the team, are thankful for those who constantly liked our Facebook page, and also those who subscribe to our channel. And if you like this video, please hit the like button in our Facebook, and please subscribe to our YouTube channel. And our work in progress, the LexClassroom website. Since I'm very busy with my work, I still have to find time reviewing the contents, but we are doing the LexClassroom website because this is a way to accommodate those people who have auditory concerns. And actually, there are a few people who extended or sent a message to us. So, thank you so much for listening, and please look forward to our next topic next week.